Assistant Public Defender Nicholas Bukovich on behalf of Mr. Humphreys.
Okay, go ahead.
Hi, Your Honor. We'll be requesting a brief adjournment for some further negotiations. Mr. Humphreys we've been working on a release for treatment with him. I've been in contact with Sarah Stewart, and he may be released to treatment soon, so that may play a part in the plea negotiations.
And that's correct, Your Honor.
All right. Probable cause conference will be adjourned July 31st, 2025, 9 a.m. Bond continued. Let's call the case of the people versus Frank Clark.
On behalf of Mr. Clark, who should be appearing by Zoom.
Forgot to give it to you.
All right. You're asking for an adjournment of the probable cause.
Yes, Your Honor.
I'll give you a date moment depending on the outcome of your bond motion. Go ahead.
Your Honor, provided the court with a letter from Second Baptist Church, Reverend George Waddles. The pastor is present here in court today, along with my client's
Hello,
family
Pastor.
members.
Go ahead.
If released, he would live at 111 North Adams, Apartment 1 in Ypsilanti. By profession, he's a chef. He's been a resident of Michigan approximately 20 years. Like I said, he attends Second Baptist Church. He also volunteers at Hope House. And Your Honor, he's a caregiver for family members. So he has a lot of things going on. He volunteers in his community. I understand from the last hearing that he was not candid with the court as to his consumption of alcohol. But
Well,
and I'm not
candid would be an understatement. I mean, he just outright lied.
well, I wasn't there.
That makes it no less a lie.
I'm asking if you want to hear from him.
I'll-
A humble apology.
I will certainly hear from him, but not if he's gonna sort of spew that garbage he was giving me the last time, because that's how he ended up in custody.
I apologize, Your Honor. I panicked. I apologize. Yes, I did consume.
Pardon?
Yes, I did consume, of course. But yeah, I panicked when I was talking to the guy. I apologize for our last encounter.
You consumed alcohol and when I tried to get you to just tell me that, you just lied to me. Right?
Yes, I tried to go back and you told me.
Pardon?
I tried to go back on it, but it's too late. I had already said it. So, yeah. I apologize, Your Honor.
So on the date that you drank, what happened?
What was the trigger? What made you?
Working on somebody's funeral arrangements and drink a couple beers, drink a few beers.
Okay, so
So
did you have any O'Doul's
at first, but
at first? Okay. How many O'Doul's did you have?
6.
6. And then you had how many?
Labatt's about 4.
4.
Sure.
Okay, now you know that's different than what you told me.
I was trying to tell you, but you told Mr. Allen
You were trying to tell me what?
nothing. That's what I
No,
told
no, 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 no. Let me tell you what you said, because I remember it very clearly. You told me that you had 6 O'Doul's. I told you to get to the levels that you were, if you were just drinking O'Doul's, because you were insistent on that, you would have had to have a little over a case of O'Doul's. Remember that?
Yes.
Then, at that point, you realized, well, he looks stupid, but he's not. And then you started telling me that you had 2 beers. Remember that? What?
Yes, Your Honor.
And I knew, given the level that's on here, that wasn't true. Now, the other things that you told me was that you were in treatment. Remember that?
Treatment. It's trying to go to treatment.
Well, okay. Yes.
I'm just trying to.
I don't understand the question.
You said it to me.
He said at the
Did
last,
you or did you not tell me that you were
I wasn't
in
there.
treatment or had started treatment?
We were looking for a place to go to treatment. That's where we're starting, trying to go. My insurance is different.
Let me ask you this. When you made the statement about treatment, were you trying to get this court to believe that you were in treatment?
No.
You're saying no?
Self-incriminate myself. I don't know what you want me to tell
You
you.
don't want to self-incriminate yourself?
Already done.
So see, okay. And I know you know this, but I'm just going to remind you. That's what happens when you lie.
And I apologize.
I know a whole lot more than it appears that I know. And the moment you told the people at Community Corrections about O'Doul's, I knew you were lying. That was my first start. Now, if you can tell me that you can put down about a case and 2 or 1 beer, about 25 beers, and not go to the bathroom, because that's the only way that was going to happen with O'Doul's.
That didn't happen.
Yeah, so that's was kind of the stupidity of the lie. And then it just got worse for me. And then as it got worse, then you ended up going to jail.
I get it. Oh, I get it.
So how are you going to get in? You have insurance to cover treatment?
We're working on that. We just changed insurance, so it's not clear about.
His family's here, Your Honor.
They're
Oh, I
working it
know
out.
they're here, but you told me, Mr. Brown, at the bench that he's got insurance that will cover his insurance.
They're-
And I'm just asking, will his insurance cover treatment?
We're working on that now to get a definite. Yes, it will cover some sort of treatment. Yep.
Anything from the people?
Your Honor, the people do believe that Mr. Johnson is in dire need of treatment. We do have some concerns after the statement today. He may still not understand the extent he needs treatment, Your Honor. And I did have a chance to look at the letter that Mr. Brown provided that was from Mr. Johnson's pastor. It is a lovely letter and talks about the lovely things that Mr. Johnson has done. And the people aren't arguing that Mr. Johnson is a bad person at no point. That we allege that, we're alleging that he committed a crime, and it would appear that perhaps the root of that could have been an alcohol addiction, Your Honor. And we think about treatment, that situation could reoccur. And it's not clear that Mr. Johnson understands that or the need for treatment. So we do have some concern there.
Anything else, Mr. Brown?
No, Your Honor.
Johnson, here's what I'm gonna do. I'm gonna first of all adjourn his probable cause conference to August 7th, 2025, 9 a.m. With reference to his bond, I will set his bond at a $25,000 personal recognizance bond. On your release, you are to report to the Department of Community Corrections for placement on a scram tether because you were on a
Correct.
You're gonna go on a scram tether, so I'm gonna monitor you 24/7 for any alcohol consumption. I'm also gonna order that within the next 10 days, defendant is to be enrolled in treatment. He is to notify the court that, and the prosecutor's office that he is in treatment.
How many days?
He's got 10 days to do it. If he doesn't get in, I'm issuing a warrant, or he might as well just come over to jail and turn himself in, quite frankly, because I'm gonna issue a warrant and I'm gonna have him picked up.
Understood.
You understand all of that, sir?
I do.
Thank you.
Thank you.
No, just, we'll do that.
All right, let's talk about that. This hearing might have started as just another day in court. But when Frank Clark took the stand, it quickly turned into a real-life lesson in accountability, humility, and the consequences of trying to out-talk a judge who's clearly heard it all. Things started with a simple request for adjournment from Mr. Humphrey's attorney, citing ongoing negotiations and a potential release to treatment. That part wrapped up quickly, professional, respectful, and by the book. Then came Mr. Clark, and the courtroom dynamic shifted dramatically. His attorney came prepared with a character letter from a local pastor, who was even present in court, a nice touch that spoke to community support. They were also ready to propose a residential address and emphasized Mr. Clark's history of volunteer work and caregiving, all good groundwork. But Judge wasn't about to let the prior hearing slide. Turns out Mr. Clark had not just been evasive before, he had flat out lied about his alcohol consumption. And the judge remembered every word. Let's be clear, the judge didn't fly off the handle. What unfolded was more like a controlled burn. With precise recall and growing exasperation, the judge walked Mr. Clark through his previous conflicting stories. First, it was $60. Then it was a couple of real beers. Eventually, the truth spilled out more like 25 drinks between beers and non-alcoholic brews. The judge wasn't angry for sport. He was frustrated because Mr. Clark had a chance to be honest, and instead chose to insult the court's intelligence. And to his credit, Mr. Clark owned up. He apologized directly, admitted to panicking, and tried to explain the stress of funeral planning as a trigger. Was it an excuse? No, but it was human. The most telling moment came when the judge asked if Mr. Clark had tried to mislead the court into believing he was already in treatment. Mr. Clark's response? Not quite clear, and certainly not convincing. That was a problem. Even the prosecutor, who supported treatment as a path forward, raised valid concerns that Mr. Clark might not fully grasp how serious his situation was or how essential treatment is to preventing a repeat offense. It wasn't about punishing someone for addiction. It was about ensuring the risk doesn't return unchecked. In the end, the court offered a second chance, but it came with strings. Mr. Clark was granted a $25,000 personal recognizance bond with strict requirements: report to community corrections, wear ASCRA alcohol monitor, and enroll in treatment within 10 days. The judge was crystal clear: miss that window, and the next stop isn't rehab, it's jail. No ambiguity, no do-overs. This hearing was a masterclass in courtroom candor. It showed how quickly credibility can erode, how much patience a judge can extend, and how redemption isn't automatic, it's earned. Mr. Clark got a shot to turn things around, whether he takes it. That's the next chapter. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read everyone.